Right, you've already brought her up here.
Where's she?
Every day in America, people find themselves facing the justice system. Today, Cody J. appears before the court, charged with 2 counts of 4th-degree criminal sexual conduct. Representing himself, he insists he's innocent, yet the judge must warn him of the serious consequences ahead. The room tightens as the hearing begins.
She's ready.
Is she inside?
She's
Or where-
already signed up.
No, is she in the hall or?
Everyone's in custody.
Everybody.
All right, we can only do one at a time. She's in custody?
Mhm.
This one at a time. Take the one they're working on. Who is that?
Brewer.
That's Brewer.
Okay.
He signed up too.
23 CR 1495 is now called, the state of Texas versus Lyndon Paul Brewer. You are Mr. Brewer
Yes, sir.
with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment?
Yes, sir. Yes, sir.
And can we proceed in summary?
Yes, sir.
Okay, he's 3rd-degree felon. It looks like he's an habitual felon.
That's correct,
What are
Your
we doing?
It's gonna be, the agreement was 5 years TDC. He had been
He's
on.
looking at
police-
25 to life?
Yes, sir.
That's a pretty good deal.
In this case, I believe he had spit on the police officer there. Is what just giving you
Who
the
enjoys
circumstances.
being
Yes, sir.
spat upon.
Yes, sir.
Go ahead, say something.
Like on my
You didn't
life-
do it or not?
No, on my life and my kids, man, I don't want to throw my life away.
Did you do it or
For some
not?
spit on a woman. I didn't spit on a woman.
Did you do it or not?
I didn't do it.
It's set for trial.
I didn't do it.
It's set for trial.
I didn't-
This lady has a chance to be
take my
heard.
guilt, but I didn't do it.
The
I just
lady,
want to free my soul before I take my.
all right,
That's
the
all I'm
lady-
gonna do.
the lady will have a chance to be heard. You're gonna say you didn't, you're not gonna say you didn't do it and plead under oath you did, sir. We're setting it for trial.
The judge explains the stakes. Self-representation means no leniency, no guidance, and strict adherence to courtroom rules. Cody listens, determined but unprepared. Sensitive victim information will be sealed as required. Procedures move carefully, with the judge ensuring fairness while making it clear. This case carries weight far beyond Cody's confidence.
For trial. It'll be set for trial.
Maybe say trial.
Yes, that's what we're gonna do. Let a jury decide.
So I should say guilty. But if I say guilty, he's.
You can go. You've already said that you're not guilty. I'm not going to accept you saying you're guilty under oath. That would be a lie. Honesty is something we all follow, or we're supposed to, sir. All right, that's set for trial. Thanks. 23 CR 662 is called, State of Texas versus Ashley Grant, who is charged with a 3rd-degree felony of obstruction or retaliation. And 23 CR 960 is also an indictment charging Ashley Grant with the 3rd-degree felony of harassment of public servant. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
Yes, Your Honor.
In summary, 662 alleges that on or about March 4th of 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation involving a public servant, namely a police officer. Do you understand what you're charged with there?
Yes.
In 960, this alleges on or about February 18th, which was two weeks. No, I'm sorry. Yeah, about 2 weeks prior to the event in 662, that on February 18th, 2023 in Jefferson County, Texas, this charges you with the 3rd-degree felony of harassment of another Beaumont police officer. Both of these are 3rd-degree felonies. Do you understand what you were charged with here?
Yes, sir.
In each of these cases, if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached.
The judge explains the stakes. Self-representation means no leniency, no guidance, and strict adherence to courtroom rules. Cody listens, determined but unprepared. Sensitive victim information will be sealed as required. Procedures move carefully, with the judge ensuring fairness while making it clear. This case carries weight far beyond Cody's confidence.
been reached in your cases where you would be pleading guilty, placed on deferred or unadjudicated probation for 10 years on each case. Is that your understanding of the agreements?
Yes, it is, sir.
If I follow these agreements, you have no right of appeal. Do you understand of your cases? How do you plead in each of these third-degree felonies, guilty or not guilty?
Not guilty. Guilty.
Hold on, you got a not guilty followed up by a guilty. What's your final answer?
Good,
Okay,
guilty.
yeah. Are you pleading guilty voluntarily in each of these cases? And because you are indeed guilty of.
His outburst triggers immediate warning. The judge's tone sharpens. Self-representation does not excuse misconduct. Any further disrespect, she says, will land him in custody, tether gone, freedom revoked. The message lands hard. With authority restored, the judge ends the hearing, leaving Cody to face the consequences of the path he chose.
Of these offenses.
I'm guilty.
All right, I show you what's marked as State's Exhibit 1 in each case. Did you
Okay,
sign those documents
Yeah.
voluntarily? Did you understand them?
yeah,
Discuss them with your attorney? Are the
Yes.
contents all true and correct?
yes, correct.
State's Exhibit 1 is tendered into evidence in each of these cases. Without objection, they are admitted. Among other things, State's Exhibits 1 in each case state succinctly that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You understand what you're charged with. The indictments have been read to you. You've read them. You were
Yes, sir.
guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God in each case. Is that so?
Yes,
State's Exhibit 1 is made a part of the record in each of these cases. How much time in jail? I guess have you been in jail since you were arrested?
yes, sir.
Boy, I'm looking at 662. I can't believe that kind of language from a lady
Oh. I'm sorry, sir.
you used. And to a police officer, who works for you. That's and me.
Yeah, I feel that.
And then here in
Not yet.
960, you're shouting obscenities to the officers. My goodness. And it looks like you were maybe under the influence of an alcoholic beverage.
Yeah, I dropped one time.
That doesn't make it right.
I'm sure.
Judge, for some reason, her jail card is not updated, so I don't have an accurate count of how many days she's been in jail. Let me look real quick on her warrant screen and see when that was closed out.
I'm worried. I'm more concerned about 960 where she spit on the officer on his face.
Okay, let me check that one, Judge.
You're gonna be, that's intolerable. Well, they have to face that kind of thing, but you're going to be held responsible when
Yeah.
for behavior like that, which is unsafe
Yes,
behavior
it is, sir.
under. In each of these cases, while we're figuring out, you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas in each of these cases from State's Exhibit 1 to find you guilty beyond a reasonable doubt. But I am going to rather defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years on each case. There will be terms and conditions of probation which are normal and customary for this.
Looks like August the 1st of 2023, she was arrested, Judge.
Type of offense.
Looks like she was arrested August the 1st of.
You've been in custody since August.
Yes, sir.
You will serve 60 further days as a condition of probation and 960 for that very dangerous activity that you performed on one of the public servants, you don't spit on anybody, much less a police officer.
No, I would ask her attorney, she's not saying this, but I would request the court to abate that since she has done 6 months already. If the
Not as a condition of probation. She hasn't. It says they put her in August 24th is when it's showing August 1st. So that would be, but
6 months as of.
But I think I can put 6 months as a condition of probation from the outset of probation.
You can, you're absolutely, everything right. I'm just asking the court to consider.
It's just, let me just say this, I'm just gonna say this, you don't spit on the people who represent you and me. And who are putting their lives on the line. You don't spit on their face.
No.
That carries a price. Anything else? That is all. Who else do I have here?
So happy.